After Garcia overruled National League of Cities, the role of the 10th Amendment as a constitutional check on federal regulation seemed uncertain. Another line of case law has emerged to breathe new life into the 10th Amendment, however, focused on the commandeering of state government resources. The first of these cases in our discussion is New York v. U.S., decided in 1992. Recall the cooperative federalism that we introduced in the previous unit. The notion of cooperative federalism is that some problems are best handled under a regulatory scheme that shares responsibility between the federal government and state governments. As you might guess, these tend to be large, expensive problems that potentially involve externalities, such as environmental issues. The regulatory scheme in New York v. U.S. concerned low-level radioactive waste, or LLRW. This kind of waste is produced by nuclear power plants and also by private industry, hospitals, and research institutions. Because of its radioactivity, this kind of waste is difficult to dispose of. It's particularly difficult in areas of high population density, which lack safe disposal facilities, and which also tend to be areas with more hospitals and industries that use such waste. One solution to this kind of waste disposal problem is to remove the waste from higher density areas to lower density areas. That is, from more urban areas to more rural areas, including across state lines. This can create a market opportunity in more rural areas or in less densely populated states. Of course, it also raises significant questions about the costs and risks to people and the environment of importing radioactive waste. In addition, because of the nature of this waste, it must be handled and disposed of properly in a timely fashion. This requires investment in the construction of disposal facilities. Private disposal companies may be reluctant to invest in such facilities in light of the economic and other risks of handling this kind of waste. If the government does not build and run the facilities itself, it may have to provide tax, liability, or other incentives to industry. The Low-Level Radioactive Waste Policy Amendments Act of 1984 sought to address these problems through a carrot-and-stick approach. The carrots involved, one, a monetary incentive, which was a surcharge, a kind of tax, a state with a disposal site could impose on imported waste. And two, an access incentive, which allowed a state to increase disposal costs on or deny access to imported waste that did not meet federal disposal guidelines. The stick was the take title sanction. States that failed to meet federal deadlines for LLRW disposal would automatically take title to the waste from a private entity that generated it and become liable for damages relating to the waste. As you can see, these provisions were designed to prompt state governments to take an active role in managing privately generated LLRW by encouraging the construction of disposal facilities that could handle cross-border waste and by pressuring state generators to meet disposal deadlines. Under the statute, states were encouraged to enter into regional agreements, or compacts, concerning interstate transport and disposal of LLRW. New York State did not enter into a regional compact. As you may know, while the New York City metropolitan area is one of the most densely populated areas in the country, most of New York State is rural and more sparsely populated. New York therefore initially decided to build new LLRW facilities in several of its northern counties. Residents of those counties, however, objected to this plan, raising the specter that the state would fall under the take title sanction. New York State and its affected counties therefore sued to enjoin enforcement of the statute. In the majority opinion written by Justice O'Connor and joined by Justices Rehnquist, Scalia, Kennedy, Souter, and Thomas, the court upheld the monetary and access incentives but struck down the take title provision under the 10th Amendment. Justice O'Connor stated that Congress may not simply commandeer the legislative process of the states by directly compelling them to enact and enforce a federal regulatory program. Congress could, Justice O'Connor said, use the spending power as an incentive or offer the state the option of regulating according to federal standards with the alternative of complete federal preemption of state law. Under such scenarios, where Congress encourages state regulation rather than compelling it, state governments remain responsive to the local electorate's preferences. State officials remain accountable to the people. However, she said, where the federal government compels states to regulate, the accountability of both state and federal officials is diminished. The take title provision, she held, crosses the line distinguishing encouragement from coercion. In his dissent, Justice White, joined by Justices Blackmun and Stevens, noted that the statute at issue was an example of cooperative federalism and that the state's interests were adequately represented in the political process that led to passage of the statute. In a separate dissent, Justice Stevens argued that the 10th Amendment does not prohibit the federal government from commandeering state governments to enforce federal law, even if the statute at issue were an example of such commandeering. The question of commandeering arose again in Printz v. U.S., a 1997 case involving a provision of the Brady Handgun Violence Prevention Act, often called the Brady Bill. James Brady was President Ronald Reagan's press secretary in 1981 when John Hinckley Jr. attempted to assassinate President Reagan. Here's a video of the assassination attempt.
He puts you here and then he runs around with a big turn. President Reagan! Back up! Get him out! Get him out! Get him out! Yeah, back! Get him out! No! Get the ambulance! All right, stay back! Get the ambulance!
President Reagan was struck in the chest and seriously wounded, but made a full recovery. Brady, who was traveling with Reagan, was struck in the head and suffered permanent brain damage and partial paralyzation. Hinckley, the son of an oil millionaire, had a history of mental illness, and just 4 days before he purchased the gun he used to shoot Reagan and Brady, he had been arrested in Tennessee for attempting to board an American Airlines flight with 3 handguns and loose ammunition in his carry-on bag. This sounds astonishing in our post-9/11 era, but he was released for this infraction after paying a fine. Meanwhile, Hinckley had been obsessed with the actress Jodie Foster, was stalking former President Jimmy Carter, and was flying around the country for no apparent purpose. Hinckley ultimately was found not guilty by reason of insanity in the Reagan assassination attempt. Advocates of the Brady Bill, including James Brady's wife Sarah, argued that strong background checks for handgun purchases would have prevented Hinckley's attack. The Brady Bill required state and local law enforcement officers to conduct these background checks. Law enforcement officials in Arizona, Louisiana, Mississippi, Montana, New Mexico, North Carolina, Texas, Vermont, and Wyoming, backed by the National Rifle Association, filed lawsuits opposing this provision, and 2 of those cases were consolidated before the Supreme Court. You can see here, of course, a theme we've seen before: the intersection of politics, federalism, and guns. The court divided 5-4 with Justice Scalia writing the majority opinion, joined by what could be considered the new Federalist bloc of Justices Rehnquist, O'Connor, Kennedy, and Thomas. Justice Scalia argued that there was no indication in early congressional history or the structure of the 1789 Constitution that the federal government could command state executive power absent a specific constitutional provision. A significant portion of Justice Scalia's opinion concerned a debate with the dissenters about whether the Federalist Papers anticipated the kind of commandeering involved in the Brady Bill. Justice Scalia cited the Federalist number 51 for the proposition that the separation of the 2 spheres is one of the Constitution's structural protections of liberty. The Federalist number 51, written either by Madison or Hamilton, stated the matter as follows: whilst the authority in it will be derived from and dependent on the society itself will be broken into so many parts, interests, and classes of citizens that the rights of individuals or of the minority will be in little danger from interested combinations of the majority. According to Justice Scalia, the power of the federal government would be augmented immeasurably if it were able to impress into its service, and at no cost to itself, the police officers of the 50 states. In contrast, in his dissent, Justice Stevens cited the Federalist number 27. Recall our discussion in Unit 3 about Hamilton's statement in the Federalist number 17 that the local police power is the great cement of society. In the Federalist number 27, Hamilton notes that as the national government becomes more important, it will also begin to hold society together. As Hamilton put it in characteristically florid 18th century prose, the more the operations of the national authority are intermingled in the ordinary exercise of government, the more the citizens are accustomed to meet with it in the common occurrence of their political life, the more it is familiarized to their sight and to their feelings, the further it enters into those objects which touch the most sensible chords and put in motion the most active springs of the human heart, the greater will be the probability it will conciliate the respect and attachment of the community. For this reason, Hamilton noted, the plan reported by the convention, by extending the authority of the federal head to the individual citizens of the several states, will enable the government to employ the ordinary magistracy of each in execution of its laws. As a result, Hamilton said, the legislatures, courts, and magistrates of the respective members will be incorporated into the operation of the national government as far as it is just and constitutional authority extends, and will be rendered auxiliary to the enforcement of its laws. One thing that you consider as you read these excerpts from Printz, then, is the role of the Federalist Papers in constitutional interpretation, particularly as they relate to debates about originalism as an interpretive philosophy. Notice also the comments in Justice Breyer's additional dissent. He points to the federal systems of Switzerland, Germany, and the European Union as examples of federalism in which the constituent states are responsible for implementing policy set at the national central level. What do you think of Justice Breyer's use of these examples here? What do such examples say about federalism in general or about the specifics of American federalism? The court addressed an anti-commandeering argument again in 2000 in Reno v. Condon. The statute at issue there was a privacy statute. It restricted state motor vehicle departments from disclosing an individual's motor vehicle records without the individual's consent. The statute contained a number of exemptions, including requirements for disclosures concerning motor vehicle safety and theft and other related matters. The statute applied to state motor vehicle departments as well as to any persons who obtained information from those departments, such as, for example, car dealerships that lawfully obtained information for safety recall modifications. Some states had existing laws that conflicted with the federal statute, including South Carolina. Under South Carolina law, almost anyone could obtain motor vehicle records just by submitting a request form. South Carolina argued that the federal statute violated the 10th Amendment because it would require state employees to administer the new, more restrictive records requirements. Justice Rehnquist wrote the opinion for a unanimous court, holding that the federal statute did not violate the 10th Amendment. According to the court, the federal statute at issue did not require the states in their sovereign capacity to regulate their own citizens, and only regulated the states as the owners of databases. Because the federal statute did not require the South Carolina legislature to enact any laws or regulations, and did not require state officials to assist in the enforcement of federal statutes regulating private individuals, the court found it constitutional. Reno v. Condon seemed to limit New York v. U.S. and Printz's anti-commandeering doctrine to circumstances in which states were directly required by federal law to use local resources to administer a federal regulatory scheme. The anti-commandeering doctrine received a new boost, however, in the recent sports betting case Murphy v. NCAA. The procedural history of Murphy is a bit confusing. The Professional and Amateur Sports Protection Act, PASPA, was a federal statute passed in 1992. PASPA made it unlawful for a state to sponsor, operate, advertise, promote, license, or authorize by law or compact a lottery, sweepstakes, or other betting, gambling, or wagering scheme based on competitive sporting events. It also made it unlawful for an individual to sponsor, operate, advertise, or promote sports gambling schemes pursuant to the law or compact of a governmental entity. PASPA contained a grandfather provision exempting casino sports gambling in Nevada and some state lotteries or sports pools. There was no grandfather clause for sports betting in Atlantic City because New Jersey law already prohibited sports betting. Instead, PASPA provided a one-year window in which New Jersey could choose to allow sports betting in Atlantic City. New Jersey did not exercise this option when it was available in 1993. In 2011, however, faced with a massive decline in the Atlantic City gambling industry, New Jersey voters approved a referendum amending the state constitution to allow the legislature to authorize sports gambling, and the legislature enacted such a law in 2012. New Jersey's 2012 sports betting law was challenged under PASPA by professional sports leagues and the NCAA. The leagues claimed they were concerned that the spread of sports betting would affect the integrity of their sports. Some observers suggested the leagues were mostly concerned about protecting fantasy sports gaming through entities such as DraftKings, in which some team owners held ownership stakes or marketing partnerships. Fantasy sports gaming arguably was not prohibited by PASPA because gamers wagered on individual player performances, not on the outcomes of particular games or matches. The first case was litigated through the Third Circuit. A divided panel of the Third Circuit held that PASPA did not entail any anti-commandeering violation. New Jersey filed a petition for writ of certiorari to the Supreme Court. In a brief opposing certiorari, the United States stated that New Jersey was free under PASPA to repeal its previous prohibition on sports betting. The New Jersey legislature picked up on this suggestion and enacted a repeal of most restrictions on sports betting in the state. The leagues then filed a new lawsuit claiming that this repeal violated PASPA, and that case finally was heard by the Supreme Court. Some of the argument in Murphy therefore concerns the meaning of New Jersey's repeal statute. By repealing its previous ban on sports betting, did New Jersey authorize sports betting, or is the repeal of a restriction not the same as an authorization? This was an important question, because if the repeal was the same as an authorization, then it would present a direct conflict with PASPA, which prohibited states from authorizing sports betting. On the other hand, if the repeal was not the same thing as an authorization, then there would be no real conflict with PASPA. In other words, no ripe case or controversy to decide. Of course, New Jersey might then enact specific regulations authorizing sports betting, setting up a genuine conflict, but that would become a matter for later political development. In the event, the court held that the repealer was an authorization, setting up the decision on the merits. I point this out mostly so you can see some of the subtle lawyering that often has to be done just to get to a hearing on the merits. As to the merits, Justice Alito wrote for the majority in holding that PASPA violates the 10th Amendment's anti-commandeering principle. Note Justice Alito's description of the federal legislative power. He said that the legislative powers granted to Congress are sizable, but they're not unlimited. The Constitution confers on Congress not plenary legislative power, but only certain enumerated powers. Therefore, all other legislative power is reserved for the states, as the 10th Amendment confirms. He noted that conspicuously absent from the enumerated powers of Congress is the power to issue direct orders to the governments of the states. The anti-commandeering principle, Justice Alito noted, serves three important functions. First, the rule serves as one of the Constitution's structural protections of liberty. Second, it promotes political accountability because if a state imposes regulations only because it has been commanded to do so by Congress, responsibility is blurred. And third, it prevents Congress from shifting the cost of regulation to the states. Since PASPA's ban on state authorization of sports betting unequivocally dictates what a state legislature may and may not do, Justice Alito stated, it violates the 10th Amendment. Remember, however, that PASPA also prohibited individuals from sponsoring, operating, advertising, or promoting sports gambling schemes pursuant to state law. If this provision were severable from the state authorization provision, New Jersey's victory would have been Pyrrhic. State law might authorize sports betting, but federal law would prohibit individuals from running sports betting businesses. Writing for the majority, Justice Alito held that the individual ban was not severable from the state ban, and that PASPA in its entirety was unconstitutional. I omitted Justice Thomas's concurrence from the edited text. Justice Thomas agreed with Justice Alito's 10th Amendment analysis, but wrote separately to emphasize his discomfort with modern severability doctrine. Justice Thomas believes allowing courts to sever unconstitutional provisions from a statutory scheme while allowing the remainder of the scheme to stand violates limits on judicial power. In his view, Congress adopts entire statutes, not portions of statutes, so if any portion of a statute is unconstitutional, usually the entire scheme should be invalidated. It would then be up to Congress to adopt a revised statute without the constitutional infirmity. Justice Ginsburg filed a dissent joined by Justice Sotomayor and in part by Justice Breyer. Justice Ginsburg would have severed the putatively unconstitutional provision and saved the individual ban. Do you think Murphy properly follows from New York v. S. and Printz? What about the question of severability? If Congress still wished to prohibit sports betting, could it do so?